Thank you very much, Madam President. For the past 6 months, I have been pleased to work with a bipartisan working group of about a dozen senators on potential reforms of the Electoral Count Act and some related matters. I particularly want to thank our leaders of that bipartisan group, Senator Collins and Manchin, for organizing the group, keeping us focused on getting results, and leading to a process that has resulted in a positive outcome. This week, we are unveiling our proposed legislation. Our legislation, the Electoral Count Reform and Presidential Transition Improvement Act of 2022, will reform and modernize the badly outdated 1887 ECA. 1887, the Electoral Count Act was passed. It's in bad need of reform. On July 18, 2022, the Wall Street Journal ran an editorial authored by former President Jimmy Carter and former Secretary of State Jim Baker, who had previously served as Chief of Staff to President Reagan. In this editorial, they wrote, "We stand on opposite sides of the partisan divide, but we believe it is better to search for solutions together than to remain divided. This is particularly true of a vexing problem that could wreak havoc during the 2024 presidential elections, the inadequacy of the Electoral Count Act of 1887. The act is an antiquated, muddled, and potentially unconstitutional law that allows uncertainty during a critical step in the peaceful transfer of power. Weaknesses in the law started to become apparent after the 2000 election." The editorial continues. In 2021, the ambiguities of the law helped lead to the violent assault on the U.S. Capitol as efforts were made to toss out several states' slates of electoral votes. Fortunately, those efforts failed and the rightful winners took office. But the threat of confusion remains. Left unclosed, loopholes in the act could allow a repeat of the same destructive path and occur in 2021, end quote. The Washington Post has written several editorials on this subject as well. In the June 19, 2022 editorial in the Post entitled, "Fix the Electoral Count Now Before Trump Tries to Exploit It Again," reviewed the recent House committee hearings on the January 6th insurrection. The editorial wrote, and I quote, "The House committee investigating the January 6, 2021 Capitol attack heard damning testimony detailing how President Donald Trump and a coterie of partisan lawyers advanced a dangerous argument that the vice president had the legal authority to overturn a presidential election when Congress meets to count electoral college votes. After Trump officials testified that they knew it was wrong. John Eastman, a lawyer who advocated for the theory, acknowledged as much in front of Mr. Trump on January the 4th, according to testimony from Greg Jacob, who was Vice President Mike Pence's general counsel. But Mr. Trump and his allies nevertheless waged a relentless public campaign to pressure Mr. Pence to betray the nation's democracy. Belief in the anti-democratic nonsense spurred the January 6th mob, which infamously chanted, 'Hang Mike Pence,' end quote. The Post editorial continues. Americans went most of their history without having to worry seriously about the arcane electoral college procedures. Even in closely fought, acrimonious presidential elections, losing candidates accepted their defeats with grace rather than seeking the vulnerabilities of the law to exploit. The country no longer has that luxury. Congress should have no higher priority than fixing the electoral college process, end quote. Mr. President, the recommendations that's coming out of this bipartisan group would do just that, fix the Electoral Count Act. I want to thank the work of the American Law Institute, who convened a bipartisan working group to consider possible ECA reform. In particular, I want to thank co-chairs Bob Bauer and Jack Goldsmith for their contributions to our efforts. I also want to thank the staff at Protect Democracy for their suggestions and work here. Our legislation aims to ensure that Congress can accurately and correctly tally the electoral votes cast by the states, which should be consistent with each state's popular vote for president and vice president of the United States. Our legislation clarifies some of the ambiguities in terms of the appropriate state and federal roles in selecting the next president and vice president of the United States as set forth in the United States Constitution. In our constitutional system, election laws, like many other areas of law, involve shared powers between the federal government on one hand and state and local governments on the other. Article 1, Section 4 of the Constitution provides the time, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislatures thereof. The clause of the Constitution continues by concluding, but the Congress may at any time by law make or alter such regulations. We have the power here, and that's what the Electoral Count Act was about. Article 2, Section 1 of the Constitution provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which each state may be entitled in the Congress. The Constitution also provides that Congress may determine the time of choosing of the electors and the date on which they shall give their votes, which they shall be the same throughout the United States. The 12th Amendment to the Constitution, ratified in 1804, sets out a framework for Congress to tally and count the electoral votes from the state. Congress later passed the Electoral Count Act, ECA, in 1887, in the aftermath of a contested Hayes-Tilden presidential election of 1876, in which states sent competing slates of electors to Congress. Our legislation takes several key steps to modernize the ECA and reduce the opportunity for constitutional mischief when it comes to Congress properly counting the electoral votes of the states. First, the legislation helps to make it easier for Congress to identify a single conclusive slate of electors from each state. The legislation requires each state's governor as responsible for submitting the certificate of ascertainment identifying the state's electors. A state may designate another individual besides the governor to carry out this function, such as the Secretary of State, if such individual is named before the election date itself. Again, the state executive official reporting their electoral votes to Congress must do so such under and pursuant of the laws of the state provided for such ascertainment enacted prior to election day. Our legislation therefore seeks to avoid circumstances in which a state attempts to change the rules after the election day due to political pressure that may arise if a particular favored candidate loses the election. Congress could not accept a slate of electors from an official not authorized to do so by state law enacted prior to Election Day. Our legislation provides that states following these rules will have their appointment of electors treated as conclusive by Congress, subject to any subsequent state or federal judicial relief granted prior to the date of the meeting of electors. Our legislation states that the determination of the federal courts shall be conclusive on questions arising under the Constitution or laws of the United States. Second, the legislation modernizes the failed election language of the ECA to specify that a state could modify its period of voting on Election Day only as necessitated by extraordinary and catastrophic events as provided under the law of the state enacted prior to the election date. This provision makes it clear that a state legislature that tries to override a popular vote in their state, that would not be allowed. Third, the legislation provides for an expedited judicial review of certain claims relating to a state's certification identified by its electors. We have limited this special judicial review in our legislation to only be available to aggrieved presidential candidates. This special procedure allows for challenges made under federal law and the U.S. Constitution to be resolved efficiently using a special three-judge panel with a direct and timely appeal to the United States Supreme Court. Fourth, the legislation makes clear that the Vice President has purely a ministerial role in the joint session of Congress to count the state's electoral votes. In particular, our legislation states that the Vice President does not have the power to solely determine, accept, reject, or otherwise adjudicate disputes on electors. That explicitly includes objections over the proper list of electors, the validity of the electors, or the votes of the electors. President Trump pressured the Vice President to use this illegal method in order to overturn the 2020 election results. But ultimately, this effort was rejected by Vice President Pence in his capacity as President of the Senate as he presided over the January 6, 2021 joint session. Fifth, our legislation increases the threshold needed to lodge an objection to electors from one senator and one representative to 1/5 of the duly chosen and sworn members of both the House and the Senate. Similarly, Article 1, Section 5 of the Constitution provides the yeas and nays of the members of either body, House, on any question shall, at the desire of 1/5 of those present, be entered on the journal. This will reduce the risk and likelihood of frivolous objections being lodged, which require lengthy debate and vote in separate houses. The House has to vote in one house, the Senate votes separately, and it takes a lot of time. For example, on January 6, 2021, the Senate voted to reject by a vote of 6 to 93 against the electors of Arizona, objection raised, and 7 to 92 on the objections raised in regards to the electors from Pennsylvania. 6, our legislation clarifies that if electors are not lawfully appointed or if an objection is sustained by Congress rejecting electors as not lawfully appointed, those electors would not be included in the denominator of determining the majority of the whole number of electors appointed. That means we can reach a decision on the day that we count the votes. The main focus of our work over the past 6 months has been the sorely needed reform in the ECA. But our working group came up with a number of bipartisan reforms and some other matters related to elections. The Presidential Transition Improvement Act would help promote the orderly transfer of power between presidential administrations. As we saw in 2020, the failure of a timely ascertainment of the winner by the administrator of the U.S. General Services Administration and the uncooperative attitude of the Trump administration led to a delay in providing transition resources to the incoming Biden administration. This legislation provides clear guidelines for eligible candidates for president and vice president to receive federal resources to support their transition, including during the time period when the outcome of election is in reasonable doubt. The Postal Service Election Improvement Act seeks to improve the handling of mail-in ballots by the United States Postal Service and provides guidance and best practices to the states to improve their mail-in ballot processes if the state law allows. The Election Assistant Commission Reauthorization Act will reauthorize the Election Assistant Commission for 5 years. This EAC law administers grants to states and develops non-binding guidance and best practices for election officials in various areas, including cybersecurity, election audits, and voting accessibility. Now, what this legislation does not include is any substantive provisions to strengthen voting rights in this country, which is desperately needed. And I am sorely disappointed by that omission. Our nation has a long history of bipartisan work on voting rights issues. I had repeatedly raised voting rights issues with our larger group as well as smaller subgroups on voting practices. Let me take a moment to remind my colleagues of our voting right history. The Voting Rights Act of 1965 was approved by a broad bipartisan vote, 328 to 74 in the House, and a vote of 79 to 18 in the Senate. And Congress had a long bipartisan track record of clarifying its intent in response to restrictive Supreme Court decisions. That is, until recently. In 1982, Congress amended Section 2 of the Voting Rights Act after the Mobile versus Bolden 1980 decision, in which the Supreme Court interpreted Section 2 as prohibiting only purposeful discrimination. That was very restrictive, making the Voting Rights Act much less effective. Congress responded to that decision by clarifying that Section 2 explicitly bans any voting practice that had a discriminatory result, irrespective of whether the practice was enacted or operated for a discriminatory purpose. The 1982 amendments, these are the amendments that corrected the Supreme Court restrictive decision, passed the House by a vote of 389 to 24, and the Senate by a vote of 85 to 8. They were signed into law by President Reagan, bipartisan action. Over 20 years later, Congress acted to address 2 Supreme Court rulings and clarify congressional intent regarding Section 5 of the Voting Rights Act. This reauthorization passed 390 to 33 in the House and 98 to 0 in the Senate. It was signed into law by President George W. Bush. Again, bipartisan action. So after the Supreme Court's decision in Shelby County versus Holder in 2013 and Brnovich in 2021, Congress should have acted to clarify the intent of the Voting Rights Act. But it didn't. And now we are faced today with a totally unnecessary partisan gridlock on voting rights. We saw this gridlock play out this January when the Senate refused to even take up and debate the Freedom to Vote John R. Lewis Act. So let me mention one section of the VRA in particular. Section 2 of the Voting Rights Act protects against discriminatory voting laws. It prohibits any jurisdiction from implementing a voting qualification or prerequisite to voting or standard practice or procedure in a manner which results in a denial or abridgment of the right to vote on account of race, color, or language minority status. For nearly 40 years, case laws have interpreted Section 2 to combat racial discrimination without partisan favor. Prior to the Brnovich case, the Supreme Court and several circuit courts had adopted a standard to ensure the effective implementation of these provisions consistent with the text and purpose of the Act as amended in 1982. The Brnovich decision deviated from congressional intent behind Section 2. The court adopted an unduly narrow reading of Section 2 when it went beyond the statutory interpretation by courts for decades by outlining 5 new guideposts. The decision is not tethered to the statutory text and inconsistent with the statute's purpose and historical usage. It wasn't the first time the court narrowed our law, but in previous efforts, we came together, Democrats and Republicans, to make sure that the Voting Rights Act was effective. So I'm disappointed that we could not make progress in our working group to address the needed fix to Section 2. We should have also looked at the issue of the right of private action. Since the Voting Rights Act enacted in 1965, Congress has intended that voters be able to sue directly to enforce the Voting Rights Act rather than depend entirely upon U.S. Department of Justice, which has finite resources in protecting voting rights. And I want to thank my colleague, Senator Murkowski, for consistently raising this issue. The voting rights private right of action is settled law, as Congress has repeatedly noted in its voting rights amendments. Even though the private right of action is clear and settled law, our group should have removed any ambiguity about its intent by proposing language making it more explicit the statute's existing right for private action. Just as we resolved ambiguities in the ECA and its potential misinterpretation, we should have done the same with this critical right of private action under the Voting Rights Act, a missed opportunity. As a recent report from the Brennan Center points out, state legislatures have been working to make it harder to vote after the 2020 elections, even after witnessing record turnout during the pandemic. The Brennan Center wrote that in 2022, and I quote, "State lawmakers who spent 2021 passing laws that make it harder to vote have focused more intently on elections interference, passing 9 laws that could lead to tampering with how elections are run and how results are determined. Election interference laws do 2 primary things. They open the door to partisan interference in elections, and they threaten the people and processes that make elections work. In many cases, these efforts are being justified as measures to combat baseless claims of widespread voter fraud in a stolen 2020 election," end quote. The Brenner Center noted that in many of these same state legislatures, lawmakers have continued to introduce or enact laws that restrict access to the vote. Legislation is characterized as restrictive if it would make it harder for eligible Americans to register, stay on the rolls, and or to vote as compared to existing state law. Mr. President, free and fair elections are fundamental to who we are as a nation. For this reason, I strongly support the bipartisan working group's proposal to reform and modernize the ECA. As we saw in the 2020 elections, different interpretations of the Electoral Count Act can lead down a dangerous path to another January 6th style insurrection, when former President Donald Trump and his enablers attempted to overturn a free and fair election won by President Joe Biden. Congress's work will not be complete when we pass this bipartisan proposal. We still must take up and pass voting rights legislation in order to safeguard the right to vote, which should be a right guaranteed to all Americans, regardless of their race, wealth, or social status.